I brought you back in here after you acted like that to listen to you. And then you're not going to listen to a thing I said.
Name for the record.
Rashard Young.
Your Honor, at this time, we would like to set this matter for PE.
Your Honor, two things. One will be addressing bond what time's appropriate. And then also, recently I was reviewing this case, saw on the body cam, we didn't have a different body cam. I requested that today. So we don't have all the discovery. I'm awaiting one more body cam video from a different date that is related to this incident. Your Honor, at this time, the people who said it's 25,000 without the 10%. In this case, the defendant has a companion case in misdemeanor court 1482 from 2024. It's a DV and assault with the same victim, and I believe her son. He also has a case out of Plymouth for a domestic violence with the same victim. And in this case, it is an FA with a knife in which he threatened the victim with the knife, took it out while they were arguing, pulled it out, brought it up, brought it down towards her. And while he was in custody from, I believe, 2-3 to 2-6, he made 135 calls to the victim, which was against the conditions of his bond, which was addressed at arraignment. We have great concerns for her safety as he keeps contacting her and getting new cases for domestic violence with the same victim. And we would be asking that at this time, his bond is set at 25,000 without the 10% into custody, Your Honor.
Response.
Okay. Regarding the actual charge, I did review the discovery myself. The evidence is solely the testimony of the complaining witness. There has not been any evidence of a knife. Regarding the phone calls, my client does deny all of those allegations. We have not received a violation report to discuss that with him. I was going to ask for an adjournment because we have not been able to speak about this case. I was going to ask for a week adjournment so we can go through that evidence and possibly at that point we can, address bond again at that hearing.
But he's indicating that calls were not made from the jail?
He's saying it was not him making the call. He did not make any calls to the complaining witness.
And I believe they were from his PIN to her number stated in the police report. And given that he already has multiple other cases with this victim, I have great concerns that he would still be contacting her out of custody.
I would ask, he is, your phone was on.
My phone.
Oh, the phone that I give you, the iPad. It is my understanding that he is gainfully employed. He is a father. I would ask if he can remain out on bond with a tether.
Well, but I'm a bit concerned about all of this contact. I mean, I've got these cases coming up while we were at the bench so that it's clear. Prosecutors indicating to me calls are coming from the jail from up to the 6th when he's released on that day. Mm-hmm. But he's arraigned on the 4th, and it's clearly indicated he's to have no contact. So, and if it came from his pen, I mean, so I'll adjourn this to February 20th, 2025, 9 a.m. I'll adjourn it out 1 week.
Would we be provided with the calls?
Yes, I'll send those out send the email to have those released today.
I'm going to set his bond at $25,000 cash surety as the amount. What was his bond set at initially? Personal?
I believe it was the 25,000 with the 10%. And then the other case, he got a nominal $100 bond on the mistaken case.
All right. So defendant's going to be remanded. He'll need to post that. And then at this point, defendant's phone privileges, given what the court has heard, are revoked so that he'll go into the jail. He won't have phone privileges. This is the court's intention. And then you can get those through with your client, and we can figure it out next week. At this point, defendant's remanded. Court does call the case People versus Brandon Carter. I'll recall the matter of the People versus Rashad Young.
Alexander, on behalf of the people.
Oh, there you are. Okay, I didn't know where you were at. It's like, oops.
Ashley Moulton on behalf of Mr. Young.
Yes, and Mr. Young, he was taken into custody, transported down. He is not here. I'm not bringing him back up only because my understanding is the alleged victim wanted to address the court. So if we could get her. Your name?
Tandiana Yates.
All right. Ma'am, I'm going to let you know, if it weren't for the people in the prosecutor's office and counsel, I wouldn't be calling your case back up and you probably would have been locked up. I'm just going to let you know because you don't come into the court that way, ever. Am I clear?
Yes.
What did you want to tell the court, ma'am?
Okay, first I want to say I fully apologize for coming in here like that. I was unaware. I'm sorry. I just want you to know with this whole case, instead of incarcerating somebody,
Go ahead.
y'all need to try to help him. I don't know if the prosecutor let you guys know, but he has yes, I'm sorry. You can talk. I don't want to overtalk you.
Well, you'll never do that, but I'm
Well-
just going to let you know that I'm not going to sit here. You wanted to address something to the
Yes,
court.
because I feel like it was inaccurate.
I will listen to you. I'm not going to tell you or have you sit here and try to give me a lecture on how something should work.
Oh, no, I will never do that. But I just noticed when I was looking on the Zoom that it was inaccurate information stated on you guys' record. And I just fully disagree when inaccurate information is stated on something that's very important like this. With the prosecutors, they should have called me instead of giving out inaccurate information because I would have just let you guys know. Instead, when I looked on that Zoom, it was inaccurate information stated on this, I don't know what you call in this courtroom. And I just fully disagree with that. So I wanted to make that known.
Okay, let me just say this because you kind of blurted that out when you had come busting in here.
And my apologies for
So let me just tell you so that you can understand what you're saying and what is being said. Because when you said that, which is everybody's obligation here, his counsel, the prosecutor, and even in some respects the court, to double check what somebody is saying, in particular if a decision was made based upon inaccurate information. Let me tell you that the prosecutor, as with her duty, checked what you were saying. I don't think, at least preliminarily, and I discussed it with his counsel and with the prosecutor, that what you're saying is correct, that it was inaccurate. At least with reference to what I was using for my decision on the remand. There will be a hearing that will be set next week. At that hearing, all of that will come out. But at least preliminarily, it does not look like the information that was presented to the court was in any way inaccurate. Some of the information with reference to the date, so that you understand, the court itself can tell in looking at the file and when he was arraigned. So while you may have your position that it's inaccurate, I do not believe at this time that it is inaccurate.
Okay, so is there any way that a prosecutor, someone can call my phone so we can discuss this? Because I no longer have that cell phone number and it was to my sibling. You guys stated on.
If there are references to the case, ma'am, we thought about that.
Okay,
If there are references to the case, references to you, references to other things that are occurring. So I don't think, and I said, I have not made a final decision on it certainly, but at least preliminarily what is being represented to the court appears to be true. And we will flush it out at a hearing because that's the way our system works. Preliminarily, I have that. I took what remedies need to be done to enforce the orders of the court regarding no contact. it seems that that was violated. He will have his due process right to a hearing next week regarding that.
But how is it violated when I have not physically talked to him? Just like when I came into the courtroom the first time and I sat down, he made it aware that I can't even be around him.
I am not going to have a hearing on it right now. I will listen to you.
That's just that was just very inaccurate to me. And I just felt like the way that y'all did that was no. Somebody should have.
Y'all did what? Don't you turn your back on me, because I'm telling you what, you are trying my patience.
No.
You are trying my patience. I brought you back in here after you acted like that to listen to you. And then you're not going to listen to a thing I said. I'm done. If you want to attend the hearing next week, you can come to the hearing. I've tried to explain it. You are not listening. I am done. Do not say another word to me. Mr. Allen, remove her.
Nobody.
Remove her. You keep talking and there's going to be a problem. There's going to be a problem.
If I may, Your Honor, Lauren Brown, Deputy Chief Public Defender. We did speak about that. She expects to have that today, and we think that that'll give plenty of time for us to be prepared for an example. The one works for us. We'll be ready.
It's one body cam.
I believe so, Your Honor.
Okay. There won't be an adjournment of this proceeding if that's not available, but I'll set it. Will people have their witnesses available the 4th?
We'll do our best, Your Honor.
Preliminary examination in person, March 4th, 2025, 9 a.m. before Judge Perry. Continue.
May I?
Oh, maybe not. Go ahead. I'm sorry.
Your Honor, as you probably recall, last week we addressed this defendant's phone privileges. After those were revoked, he then continued to call the victim at a different number that we have under her name as well. He called her, I believe, 23 times. There were some under his own PIN, and then after the first day he was in custody, he started using other inmates' PINs to continue to contact the victim in this case. So we have great concerns still that he is still continuing to contact her against court orders.
Your Honor, may we approach?
Yes. All right. Record should reflect we had a bench conference in this case. Go ahead. Anything?
Yeah. May I also address, our client has a job interview on the 24th of February and at 11 a.m. And we were wondering if you would able to either give a PR bond or a tether to allow him to go to the job interview.
Well, here's part of the problem with this case, and I'll certainly let the people respond. This case came to my attention for various reasons. There was a hearing, really a hearing, but I heard from the alleged victim in the case. And then upon getting more information, it seems that the parties did not stop contact upon this case and may have even appeared at court together on the date that they were here. Further, the defendant got remanded in part because of phone conversations, then gets remanded this time and still can't follow the court's order. So I'm not going to change his bond. You can certainly, after prelim, make the argument before Judge Perry, but I'm not changing anything regarding his bond. He'll just remain there, and his phone privileges are revoked, but he's still trying to have contact. So, motion for bond reduction denied. Got to follow the court's orders.
Your Honor.
Thank you, Your Honor.
What's our next meeting?
Ms. Collier?
Yes.
Your case by stipulation had been adjourned to March 6th. Yeah, I don't